This is Marc Lopez. I'm here with my good friend Enrique Flores. Enrique, say hi, man.
Hello, how are you, Mark? Thanks
Not
for having
bad.
me.
Oh, I appreciate you doing this with me. And I've actually known Enrique going on about, I want to say like 10 years at this point. It's been like on and
At
off for a
least.
while. And
Yeah.
right now we are serving on a committee together, solo small firm committee, and it is a lot of fun. Get to spend a little extra time with him. And Enrique has an amazing practice here in Indianapolis doing injury and workers' compensation. So Enrique, tell us a little bit about your practice.
Well, just like you said, I do personal injury and workers' compensation. And I have a lot more Spanish-speaking clients because I'm bilingual, and there's a great need for that. So I have clients that are undocumented, that are documented, that are DACA, non-DACA. So it brings a great mix of clients, and it's great to be able to help them.
Absolutely. And I love it when I get a call for workers' compensation. I know that if I send them to Enrique, he's going to be able to take care of them. Doesn't matter what language they speak. And he's just a very hard worker. So I just
Thank
want
you.
to talk to you about workers' compensation. So I know that a lot of people know that if you're injured on the job, workers' compensation is how you get taken care of. But give us some background on that.
Sure. Well, in Indiana, if you're injured on the job, and let's say that it is established that you're an employee, that usually means a W-2 employee. The benefits that are owed to you are your treatment until you're released at maximum medical improvement, weekly benefits as in payments, they're called TTD, and those are paid if a doctor says that you're not able to work, or if you're restricted from working to a point where the employer cannot offer you a job at that point. So those start paying at 2/3 every week. Then at the end of the case, you have the right to a payment for your indemnity. That means the permanency in your injury. And they also have to pay for whatever future treatment you require. So I've had cases where people end up in a wheelchair, and the insurance company either has to arrange a lump sum payment for those future needs of this client within the act, or to keep the claim open and just pay as they go. So, but those are the basic benefits when you're looking at just a workers' compensation case with no complex issues.
Enrique, one of the things you mentioned is, they have to pay 2/3 salary if a doctor says you can't go back. Does the employer have the right to offer you some alternative position? So if you can't bend over, can they offer you a seating job and you have to accept this different position?
Right, and it all depends on the restrictions. So let's take a back injury, and the doctor says the person cannot bend or lift anything over 20 pounds. Yes, you present your restrictions to the employer, and the employer can accommodate you. A lot of the times they can put you at a desk job, or just supervising, answering calls, whatever it is. So they can, and they mostly do. Sometimes, as I mentioned before, though, if the restrictions are to a point where the employer says, well, I can't have you here, just go home and get through the treatment, then that's when the benefits kick in.
And if the employer does offer you, accommodate you a different job, you have to accept that, or is it?
It depends. I've had cases where the doctor has said, well, these are the restrictions, and the employer somehow finds a way. And I've had extreme cases, of course, where a person was supposed to lay down every hour for 15 minutes because that's the only way that they could alleviate the pain. Well, the employer put a camping cot in the office, and I mean, this is low to the ground, and he has a major back injury, and he can't get all the way to the ground. and do that. So that's an instance where we actually had to fight where you don't have to take that. But if it's reasonable, and if you do have a major injury, but let's say that the restrictions say, well, the person has to be able to get up and walk every hour for 10 minutes, and they offer that, fully knowing what the restrictions are, then yes, the person in a way has to take it.
No, that's super interesting. And if you're injured on the job and you're fighting about with your employer, like you're saying, you had to fight when this person couldn't lay down, you're talking about going to an actual courtroom. Like, if you're injured by injured in a car crash, what is the litigation process in workers' compensation?
Well, we're all used to what we see on TV, right? What the litigation is. You go in front of a judge and it's exciting, and this exciting. Is nothing like that. This is nothing like that. It can be exciting in a different way. But no, it's not a formal courtroom. It's an administrative process. So meaning that the Workers' Compensation Board is the one that, the party that, the department that governs this or that adjudicates this, meaning that they're the ones that act as the judge and where you can go have your hearing. So in a way, it's a informal setting of a civil court, or like in your case with the criminal cases. You still have, though, we call them single hearing members, or you can call them judges. But there's certain steps that you have to take before you can go to a civil court. You can, but that's a process of appeals. But as far as litigation, you follow some of the rules of the civil litigation side, but it's all done within that body of the board, Workers' Compensation Board. So it is a little bit different.
And that's over at the Indiana Government Center, am I right? Those single hearing?
Yes. Yes. So the main office of the Workers' Compensation Board is at the Government Center South, right there on Washington Street, and that's also the single hearing member for Marion County. There's different regions throughout the state. The one I work most on is Marion County.
So not if people from Lake County aren't driving down to Marion County for their hearings, am I right about that? Or
you are correct. And the only time that they would is so, for example, Lake County has its own hearing member and a local office where we could go local court, I guess, if you want to call it that. But let's say that they get through the single hearing member. If they appeal it to the full board, then that's the only time that they would have to come over here, because that means all the hearing members plus the chair of the Workers' Compensation Board. But an injured worker that lives and works in Lake County does not have to come all the way to Indianapolis to have a hearing. No.
Enrique, so you've been doing workers' compensation litigation for quite some time. What are the top 3 things you see injured workers do that can hurt their claim?
Wow, I just spoke with a client this morning about that. It was a prospect, actually, a new client that called us this morning. And she was afraid of getting injections in her neck for, she has a concussion, possibly more. But she mentioned how she may want to tell the doctor that she doesn't want the injections because she's had injections before in another part of her body, and they didn't work, and then she feels that it got worse. So I would say the number one thing is denying treatment that a workers' compensation doctor or a doctor that's treating them has recommended. That can actually hurt your case. First of all, they can deny benefits, and they can use that against you. Second thing is reporting the injury in a timely manner. It is hard enough when it is reported on time and it is denied for whatever reason. But when you have something that, let's say that the person thought that just telling their supervisor was reporting it. 3 months pass by, nothing happens, and they never check back because the pain is there, but they have to work, and they never followed up. So now we have an issue because they're calling me and saying, well, I had to go to my own doctor for this. So now we have to fix that and make sure that the employer is going to pick up their claim. Now in Indiana, there's really no codified time to report, meaning that if you reported it a week later, it's still fine. Month later, it should still be fine. But there's no time where they say, well, no, if you don't report it by 90 days, it's automatically denied. So we can work with that. Now, probably the third one, there's so many that come up, but I would say the third one is the fear of undocumented people, that their claim might get dropped or that their claim might not get picked up because they're undocumented. Well, I would say half of my Spanish-speaking clients that are workers' compensation clients are undocumented. And when they call me, the first thing I want to do is make sure that they're asking me that question, clarify that they are undocumented if they are, and just tell them, look, that's probably not going to be the biggest issue in your case. And it usually isn't. Maybe the timely reporting or denied benefits or the way the accident happened, that might be the bigger issue in the case. So I just want to, that's the number one thing that I see within the Hispanic community that comes up. And just but the first thing that we do is just to ease their mind and say, look, this is probably going to be fine.
No, that's I'm sure that's got to be a heavy burden on some people because, there's genuine fear in the community, bringing too much attention to yourself. And then you made an interesting statement there about, they went to their own doctor. When you are injured on the job, do you have the right to go to your own doctor or do you have to use the company doctor?
You have to if you want to keep those benefits and if you want to make sure that they're going to cover it. So in Indiana, you have a trade-off. First of all, it is we fight for as many rights as our client can get, as the injured worker can get, because we have so little and the employers get so much. It's a trade-off. So yes, they get the benefits. Yes, they get the payments, but the employer gets to choose what doctors to send them to. These are doctors through their insurance company. They know the doctors know where the money is coming from. And we see a lot of times that very competent doctors usually rush people through treatment because of that. So while that happens, at the very least, a person will get a baseline for treatment. Now, if they need to get treatment on their own, for example, a person wakes up at 2 a.m. and they're in so much pain because the pain medication is not working and they had a setback at physical therapy, my answer is always just go to the emergency room. We'll deal with it later. But in a non-emergency setting, if the person says, well, I just don't like this doctor, I'm going to go on my own to another doctor, that's called unauthorized treatment. And it doesn't mean that you didn't need it. It just means that it wasn't directed by them. And that's something, again, that we have to deal with as the case goes on.
It's so interesting. And in your opinion, is Indiana's workers' compensation scheme one of the better ones in the country or one of the worst or middle of the road?
Well, I can tell you that we are ranked probably toward the bottom, usually between the 46th and 48th place out of 50 states. It's something that we keep in mind when we talk about this, right? Or when I meet with my clients or when I tell them that they need to follow their treatment and not be late and all this because of that, because it's so little that we can get for them. We're trying to stretch it, that we need to be able to claim what we can to get as much as we can out of the what the act provides. And as I told you before, the employer gets a lot of rights out of this. The main thing out of the Workers' Compensation Act is that they wanted to provide treatment for an injured individual and benefits for an injured individual without having to bankrupt these companies and keeping all of that. But at the same time, it is very heavily in favor of the employer. So yeah, it's one of those where it's hard on the employees, especially when you have to have the conversation that there's no pain and suffering in workers' compensation in Indiana.
No, that is, I hear this countless times, and you hear stories of two people injured very similar ways. One person in Illinois, one person in Indiana. Illinois treats them completely different than Indiana, and it's not, Indiana's treating people much worse. And, I can hear you talk, you have to fight for everything here. That's what I understand. I know you're good at that. And so I appreciate you taking care of my referrals, and it means a lot. Enrique, you gave us 3 things here. Follow doctor's orders. You said, let the employer know that you're injured. And, if you have concerns, talk to them with your attorney. Any other parting advice for anybody listening to this?
Just be careful. And of course, there's only so much you can do especially when you're working with others. But if you are in a situation where you are injured, just do anything you can to help yourself. I've had clients that have gotten kicked out of a doctor's office because they got in a fight with a doctor instead of coming to me and talking about it and making sure that we fix it. So just help yourself. And I know that it is extremely difficult, especially for a lot of these workers that are used to providing for their families, and all of a sudden they're strapped or there's no money coming in. So just keep a cool head as much as you can, and just call us with questions. That's my main advice.
Thank you so much for spending some time this afternoon talking with me, man. I appreciate it.
Thank you, Mark, and thank you for providing the forum for this.
Absolutely. What's the best way to get a hold of you? If anybody listening wants to give you a call.
Yeah, they can call me for both Spanish and English service, 317-900-2556.
You have a great day, buddy. Have a great one.
Thank you very much, Mark.
Absolutely, buddy.